So in the previous class, we have discussed Article 25 of Indian Constitution. That is, we are talking about right to religious freedoms. Right? That is, right to religious freedoms, that is from Articles 25 to 28, and as a part of it we have discussed Article 25, where Article 25 provides every individual the freedom to practice, profess, conscience of religion. At the same time, the same article also empowers the state to make laws for regulating those activities which are not prescribed by religion, right? So Article 25, on one hand, it provides freedom to the individual. On the other hand, it provides the power to state for making laws, right? So there are two things. One is freedom of individual. Second one is power to make laws. So state is empowered to make laws, and the law that is made by state is equally applicable. It is equally applicable to all the religions. That means there is no discrimination. In application of such laws. So it is equally applied. To all the religions. So there is no discrimination. In such application of laws. Alright. So this is what Article 25 says. So Article 25 states that every individual has the freedom to follow the religion, right? They can profess, they can practice, they can freedom of conscience of religion, right? At the same time, state has the power to make laws to regulate activities, those activities not prescribed by religion. Alright. So this is Article 25 says. So regulating the activities not prescribed by religion. Alright. Ultimately the purpose of the state is to protect the secular character of the nation, because secular character is a fundamental feature of Indian society. It is regarded as a basic structure of Indian Constitution, right? So that means at any cost this secular character should not be violated. This secular character should not be compromised, right? In the recent past, we have seen many debates on this issue, right? So in the ongoing general elections, right? So this has become the bigger a point of debate between the ruling parties as well as the opposition parties. But remember, whoever comes to power, right? Ultimately, the purpose of the government is to protect the secular character. So this was clearly upheld by Supreme Court. This was clearly said by Supreme Court in S.R. Bommai versus Union of India case. It is clearly given in S.R. Bommai versus Union of India case. It is clearly given in S.R. Bommai versus Union of India case. Alright. So that is what Article 25 says. Alright. So we have discussed till this point in the previous class. Alright. Now going ahead, alright, coming to Article 26 of Indian Constitution. If you take Article 26 of Indian Constitution. So this Article 26 of Indian Constitution All right. It provides the freedom to manage religious affairs, freedom to manage the religious affairs. So every individual is given this freedom. Every individual enjoys this freedom to manage their religious affairs. So it is up to the individual. They can, all right, they can celebrate or they can manage their own religion according to the principles of the religion or according to the principles of that faith. So there is no restriction on the individual. All right. So construction of temples, having Ratha Yatras and all these processions. All right. So having of different forms, because every religion has their own form of celebrating religion. Every religion has their own form of following their principles. All right. It is up to the individuals. So every individual is given this freedom to follow the freedom to manage their own religious affairs. All right. So construction of temples, right, having of processions, right, having of meetings, right, going for prayers, it can be anything. So every individual, they can follow their own, they can manage their own religion. But though the individual has this freedom, though the individual has the freedom to manage their own, manage their religious affairs, but still the state has every power to regulate, right, the activities which violate secular character. That means though the individual has the freedom to manage religious affairs, but the state has every power. The same Article 26 in class 2, all right, the same Article 26 has empowered the state to make laws, to regulate the activities, that violate secular character. That means state can impose a reasonable restrictions. State has every power to impose reasonable restrictions on those activities of the religion which may affect. Right, so that is just now we have said that every individual has the freedom to manage their own religion. Every individual has the freedom to manage their religious affairs. But the point here is, though we have the freedom, but this freedom should be enjoyed within the conditions imposed by the Constitution. Remember, we are being given freedom, at the same time we are also being given the conditions within which we can enjoy these freedoms. All right. So which includes the secular character. So secular character is a condition. So we can manage, we can have a procession, we can go for meetings, we can conduct prayers, we can do whatever we want. But what is required is the secular character of the state should not be violated. The secular character of the society should not be violated. There should not be any harm to public order. Now that means what? Right, whenever state feels that there is a threat to secular character, whenever there is a threat to public order, that is when, right, based upon the established facts. So government or state cannot act imaginarily. The government cannot act, right, without any a concrete evidence. That means whatever governments act, every act of the government should be proved in practice. That means whenever government proves that there is a threat to a public order or to the secular character, in such condition the state has every power to impose restrictions. Reasonable restrictions can be imposed. Reasonable restrictions can be imposed on the freedoms of individuals. All right. So say for example, there are different organizations. Every religion has their own organization. They want to have a procession. Right? But here, when that group or when that community, right, want to take the procession, government can impose reasonable restrictions. There can be restrictions in the form of timings. There can be restrictions, right, in the path of that procession. So government by a law can impose reasonable restrictions, and particularly the guideline for imposing a reasonable restriction is the secular character. Right? So Article 26 of the Constitution provides every individual the freedom to manage religious affairs, but the same article also allows the state to make laws to regulate those activities which violate the secular character, right? So this is what Article 26 of the Constitution, and here either you take 25 or you take Article 26. In both these articles, in both these cases, state is given every power to make laws. State is given every power to make laws, and all such laws made by state, they are applicable to every religion. There shall not be any kind of discrimination. There shall not be any kind of discrimination in application of laws. Alright? So every law that is made should be equally applicable to all the religions, and ultimately the purpose of this law is to protect this character. So always remember the case of S.R. Bommai. S.R. Bommai versus Union of India case. Now you should remember all this. It is an important case law. Right? So both for Article 25 as well as for Article 26. Right? This is the important case. Right? Now coming to Article 27 of the Constitution. Coming to Article 27 of the Constitution. Alright, so this Article 27 provides freedom from payment of religious based taxes. That means, alright, every individual is given freedom from paying any kind of tax in the name of religion. In other words, the state is not allowed to impose any religion based taxes. The state is not allowed to impose any kind of religion based taxes. Right? Say for example, all right, there were days in Indian history where taxes were purely based upon religion. Right? So there were religion based taxes. Say for example, during the times of Tughlaqs, during the times of what you call Mughals even. All right. There was a tax called as jizya. Jizya. Z-I-J-I-Y-A, jizya. Right? So it is a tax imposed only on Hindus. Right? So this is an example of religious based taxes. It is an example of religion based tax. Alright. So there was history, there was a point in Indian history where taxes were imposed on Hindus. Alright. So in the name of religion. Right. But in the present day system, in our constitution, there is no such taxes allowed. Right. So no religion based taxes are allowed in Indian constitution. So Article 27 of Indian constitution provides this freedom. Article 27 of Indian constitution provides the freedom from payment of any kind of religion based taxes. So it is freedom from payment of religion based taxes. Religion based taxes. Alright. So this is alright. But here we should remember one point. Though the individuals are given freedom from payment of religion based taxes, but the state has every power to collect fees. Right? So always make a difference between taxes and fees and penalty. Alright. So freedom is given from payment of taxes, but not from collection of a fee and penalty. So Article 27 doesn't provide any kind of protection. There is no freedom from payment of fee or penalty. Let me explain this point. All right. So Article 27 allows, the state, Article 27 allows the state to collect fees, for all the services rendered, for all the services rendered by state, right? The state has every power to collect fees, right? That means normally you take government provides the revenue services and more importantly the police service, right? So government provides, you take any religion, right? So during processions, during celebration of festivals, alright, it can be anything. Say for example, I'll take the best example of Ganesh immersions, right? During the times of Ganesh festival, alright, there is police service given, at the same time there is revenue service given by the state, alright. So government has every power, power to collect fees whenever it provides any such services. Whenever any such service is given by the state, right, the government has every power to collect the revenues. Government has every power to collect the fees. So here fee is allowed because for the services given. So there is a nexus between, there is a connection between the fee collected and the services rendered by the government. So whenever government provides any kind of service, for such service the government can collect the fees. And in case of non-payment of fee, the state has the power even to collect penalties, right? So collection of fees and collection of penalties both are allowed under Article 27 of Indian Constitution. Right? So the point that we should remember here is, right, clear difference between the taxes imposed and the fee collected, right? So make this difference, right? So this is about what you call Article 27, right? I think you are clear about Article 27. Okay. Now coming to Article 28 of Indian Constitution. So if you take this Article 28 of Constitution, Article 28 of Indian Constitution deals with freedom from attending religious instructions, right? It is freedom from attending religious instructions. That means no individual, no citizen of this nation should be forced, right, to attend any kind of religious instructions, right? So no citizen is allowed to force, no citizen can be forced to attend any form of religious instructions, right? That means attending religious instruction should be a voluntary act of the individual, right? It should be a voluntary act, right? That means there should not be any kind of force or there should not be any kind of pressure on the individuals, right? There should not be any force or pressure that should be imposed on the individual from attending the religious instructions, right? So every individual has this freedom. From attending religious instructions, right? So no person shall be forced from attending such instructions, right? This is one thing. And coming to another part of the same article, if you take another part of same article, in this article 22, in this article 28, alright, no state-run institution, no state institution or no state-run institution should provide religious instructions. That means no government institutions should provide any kind of religious instructions, whether it is educational institutions, schools, colleges, or any government office. That is, no state agency is allowed. Government institutions, government agencies, government bodies, they are not allowed to provide any kind of religious instructions. So religious instructions are strictly prohibited in any government run institutions. అంటే గవర్నమెంట్ స్కూల్స్లో కానీ కాలేజెస్లో కానీ ఏ గవర్నమెంట్ వ్యవస్థలో అయినా సరే రిలీజియస్ ఇన్స్ట్రక్షన్స్ ఇవ్వడానికి వీల్లేదు. రైట్. సో the state is not allowed to provide any kind of religious instructions, right? So there is a clear restriction on this state run institutions. So state run institutions, state aided institutions, that is all those institutions which receives aid from the state or which are partially funded by the government, either fully funded by government or partially funded by government. అంటే గవర్నమెంట్ నుంచి ఫండ్ అవుతున్న ఏ ఇన్స్టిట్యూషన్ అయినా సరే, ఐదర్ ఫుల్లీ ఫండెడ్ ఆర్ పార్షల్లీ ఫండెడ్, దే ఆర్ నాట్ అలౌడ్ to provide any kind of religious instructions. Right? They don't have the right to preach religious instructions. Alright? So that means, and here the individuals, the citizens are not forced, the individuals cannot be forced from hearing such religious instructions. There are two things. One is freedom of individual, and second one is restriction on the state, restriction on the government institutions. Alright? These are two elements that we should remember. Alright? So these are two things that we should remember. Alright? So this is what Article 28. Right? So Article 28 is about freedom from attending religious instructions. అంటే ఎవరిని కూడా బలవంతంగా రిలీజియస్ ఇన్స్ట్రక్షన్స్ని వినడానికి ఎవరిని కూడా రిలీజియస్ ఇన్స్ట్రక్షన్స్ని బలవంతంగా ఫోర్స్ చేయకూడదు. రైట్? ద ఇండివిజువల్ షుడ్ నాట్ బి ఫోర్స్డ్. The individual should not be forced from hearing such religious instructions. Alright? So this is what the point is. So these are different provisions on religion. Right? So let me once again rewind all these provisions. Alright? Say for example, alright, so we have started our discussion from Article 25. Alright? So let me list out all these right to religious freedoms. So 25 to 28. So if you take this 25, it is freedom of religion. It is freedom of religion. That is profess, practice, conscience of religion. 26, it is freedom to manage religious affairs. Freedom to manage religious affairs. 27, it is about freedom from payment of taxes. Freedom from payment of religion-based taxes. Religion-based taxes. Article 28 is freedom from attending religious instructions. Freedom from attending religious instructions. Right? So these are different freedoms, and remember the purpose of all these freedoms, the purpose of all these freedoms is, on one hand, providing individual the liberty, at the same time protecting the secular character. The purpose is to provide the individual of their liberty and protect secular character. So both are clearly balanced. Both are clearly balanced in Indian Constitution. So there is a clear balance established. There is a clear balance established about these what you call freedoms, right? So this is what about the religious freedoms, right? Take down a question in this regard. Take down a question. Explain how Indian Constitution provides religious freedoms, and what are the constitutional limitations on these freedoms, and what are the constitutional limitations, on these freedoms. So explain how Constitution provides religious freedoms and what are the constitutional limitations on these freedoms. There are two elements. So you need to explain both these things. Am I clear? Alright. So I really appreciate those candidates who are continuously writing answers. I really appreciate. Right? There are a few students, right, who are constantly writing the answers. Right? So if you keep on doing this, if you make this as a habit of writing answers, definitely you will have a very good day in UPSC. Alright. So next moving on to educational and cultural rights. Cultural and educational rights. Cultural and educational rights, which are mentioned in Article 29 and Article 30 of the Constitution. So both Article 29 and Article 30 of the Constitution, they talk about this. And remember, these are the rights which are exclusively given to. These are the rights which are exclusively given to citizens of this nation. That means a foreigner or any other non-citizens, they don't have these rights, right? So both are the rights mentioned in Article 29, the rights mentioned in Article 29 and 30, they are the exclusive rights. They are the exclusive rights given to citizens of this nation, right? So if you take this Article 29, so it protects the rights of minorities, right? So remember, you can also call them as rights of minorities. It provides every individual the right to protect their own culture, own language, freedom of culture, that is right to protect language, culture and their customs, right? So culture, language. So remember one point, whenever we talk about minorities, it is not about religious minorities. It is not about religious minorities. Remember, it is, alright, a linguistic minorities. It is linguistic minorities. So whenever we talk about minority in the Indian context, particularly in Indian Constitution, we should see in terms of linguistic minorities and cultural minorities. those people who have their distinct culture, those people who have the distinct culture, norms, all right, traditions, way of living, their own language, all right. So if you take, I'll take the example of language. Remember, if you take officially in 8th schedule, we have only 22 languages which are mentioned. In our 8th schedule, in 8th schedule of Indian Constitution, in 8th schedule of Indian Constitution, it is 22 languages which are mentioned. But remember, if you take Indian society is always known for its diversity. Right? Indian society is always known for its diversity. Right? So unity within diversity. So we have linguistic diversity, cultural diversity, existence of multiple cultures in India. So our constitution provides every individual the right. Our constitution provides every individual the right to protect their own identity, their own culture, their own language. So nearly there are 2,200 languages being spoken in Indian society. Right? Officially it is only 22 language, but we have nearly 2,200 such languages in India. So different languages, they have their own dialects. Right? So our constitution allows to protect these kind of diversity. So under Article 29 of the Constitution, every citizen of this nation, they have the right to protect their culture, they have the right to protect their identity, they have the right to protect their language. I'll take one simple example. All right? How many of you know about the language of Tulu? Tulu. Now people from Karnataka, they might know, because it is a language used in what you call Coorg region. Coorg, or in the well-known place in Coorg is Mangalore. All right? So it is Tulu, which is not mentioned in 8th schedule. So it is just an example. It is just an example to show that there are languages which are even outside of Indian Constitution. There are languages which are even outside of Indian Constitution. So every individual has the right to protect their language, and this is the right mentioned in Article 29. Every citizen of this nation has the right to protect their own language. Right? Now coming to Article 30 of Indian Constitution. If you take Article 30 of Indian Constitution, Article 30 of Indian Constitution provides every individual, every citizen of this nation, all right, particularly the linguistic minorities, all right, to establish and administer educational institutions. Right? So minorities in India have the right, right? They have the right to establish and administer educational institutions. Establish and administer educational institutions. Right? So this is a right given. This is a right given to the individuals. It is a right given to the individuals. Right? So every minority in India have the right to establish and administer educational institutions of their own. And here state is not allowed to show any kind of discrimination in such establishment or in administration. And when a law is made by state to regulate these institutions, this law is equally applicable to all the minorities. Right? So state has every power. State has the power to make laws. State has the power to make laws, but here the law that is made by state, the law that is made by state, it is applicable. It is applicable to all the minorities. It is applicable to all the minorities. Right? So we have different types of minorities, which, right, who have their own language and culture. Right? So every minority have their own. So again, I want to make a caution. Again, minority means the one who are less in terms of population and who have their own culture and a distinct language and distinct culture. Right? So again, once again I am repeating. So it is these people, it is these minorities who have the right, who have the freedom, right and freedom to establish and administer educational institutions of their own. And you know, and today we know, right? So every minority have their own colleges, schools, colleges. We have Christian minority, Muslim minority, Sikh minorities, right? So Buddhist, Jain colleges, right? So this is what Article 30 provides. So this right is mentioned in Article 30 of Indian Constitution. Article 30 of Indian Constitution provides, Article 30 of Indian Constitution provides this particular right to establish and administer educational institutions. Alright. So this is about educational and cultural rights. Now coming to the most important right in Indian Constitution, that is Article 32. That is Article 32. And Article 32 is regarded as, Article 32 is regarded as, how it is called as? It is called as bulwark of Indian Constitution. Bulwark of Indian Constitution. Article 32. Article 32 is regarded as bulwark of Indian Constitution. Right? So it is called as heart and soul of Indian Constitution. Dil ka dhadkan. Heart and soul of Indian Constitution. Article 32 is regarded as heart and soul of Indian Constitution. Alright. So what does this Article 32 provides? So what is this Article 32 provides? It provides constitutional remedies. Article 32 provides constitutional remedies. It provides constitutional remedies. That means without these remedies, there is no meaning for providing fundamental rights. There is no meaning for providing fundamental rights without having these remedies, because these remedies acts as a guarantee. These remedies, they act as a guarantee. Guarantee for what? Guarantee for fundamental rights. They act as, right, these remedies acts as a guarantee. That means the fundamental rights are guaranteed by Indian Constitution. The fundamental rights are guaranteed by Indian Constitution. So there are rights mentioned, right? At the same time, there is a guarantee given, right? So that is the form of remedies, and these are remedies, right? They are in the form of writs. So these are called as constitutional writs. They are called as constitutional writs. So these are the constitutional writs mentioned in Indian Constitution. So there are writs mentioned in Article 32. Alright. So right, ultimately it is Supreme Court. Ultimately it is Supreme Court, alright, which acts as a guardian of fundamental rights. It is ultimately Supreme Court which acts as a watchdog of fundamental rights. Remember this point. So it is Supreme Court which acts as guardian, which acts as watchdog, which acts as a guardian and watchdog of fundamental rights. Watchdog and guardian of fundamental rights. And Article 32 empowers Supreme Court. Article 32 empowers Supreme Court to issue these writs, right? So writs are issued. Writs under Article 32 are issued by Supreme Court, right? So Article 32 empowered, right? Constitutionally, Supreme Court is empowered to issue the writs, right? And the purpose of the writs is to protect the fundamental rights of the citizens, right? The purpose of the writs is to protect fundamental rights of the citizens, right? So this is that is the reason why Article 32 is regarded as bulwark of Constitution or heart and soul of Indian Constitution. It is called as heart and soul of Indian Constitution because of this reason, right? And there are 5 writs mentioned in Article 32, right? So in Article 32 we have 5 types of writs mentioned. There are 5 types of writs mentioned in Article 32, right? So let me talk about these writs in detail. The first one is habeas corpus. The first one is habeas corpus. Second one is mandamus. Second one is mandamus. Third one is prohibition and certiorari. Prohibition and certiorari. Fourth one is quo warranto. Fourth one is quo warranto. Alright. So that is these are. So here I have placed both prohibition and certiorari in same category. Right. So these are 5 types of writs. These are 5 types of writs which are mentioned in Article 32. Right. So before going to this writs, let me talk about the impact of national emergency. So already in the previous class I have mentioned about the impact of national emergency on fundamental rights. Alright, and I want the people who are in online, please try to give answers. Right? Though you are not in front of me in the class, but still try to respond, try to give the answers. Alright. So if you take this impact of national emergency, impact of national emergency. So what is the impact of national emergency on fundamental rights? Is there any impact of national emergency on fundamental rights? Is there any impact of national emergency on fundamental rights? Right, so definitely yes, there is an impact. Alright, so we have seen, right, we have seen both what you call Article 358 and Article 359 of the Constitution. So what does Article 358 says? What does Article 358 says? So if you take this Article 358, Article 358 states that, right, whenever national emergency is imposed, the freedoms mentioned in Article 19 are automatically suspended. Right? According to Article 358, the freedoms that are mentioned in Article 19 are automatically suspended. Alright. So this is one thing. Second thing, not only Article 19, President by an order, according to Article 359, by a President order, that is by an order of President, any of the fundamental rights can be suspended, right? according to, that is by an order of president, by a presidential order, any of the fundamental right can be suspended according to article 359 except the rights mentioned in what? Bring me my mobile. Bhagya, phone తీసుకురా నా phone, because I want to see the phone now. Okay. Alright. So, except the rights which are mentioned in Article 20 and 21. Except the rights mentioned in 20 and 21, right? That means what about the impact on Article 32? Whether Article 32 can be restricted or not? Can there be a restriction on Article 32 or not? Yes, right. There can be a restriction. There can be a restriction on Article 32. So, Article 32 can also be restricted. That means what? The remedies which are mentioned in Article 32, they can be restricted during national emergency. So, this is a very important point that we should note, right? So, except 20 and 21, by presidential order, any other right can be restricted, which includes even Article 32, because, so this was a point of debate. So, whenever a national emergency is imposed, alright, Article 32 can be restricted, but not the entire Article 32. So, though Article 32 can be restricted, but not the entire Article 32, right? So, there is a limitation, because if we take Article 32, we have different types of writs. So, except the writ of habeas corpus, any other writ can be restricted during national emergency. So, during national emergency, any other writ can be restricted except the writ of habeas corpus, because the purpose of this habeas corpus is to protect the life and liberty of individuals. If we take this 359 clearly exempted both 20 and 21, right? That means at any cost, at every point of time, even during national emergencies, right, the right to life and liberty of individuals, right, is always protected. There cannot be any kind of arbitrary conviction of individuals, right? That is, if you take Article 20 provides, right, protection in respect of conviction in certain offences. We have seen this. So, even during emergencies, the right to life and liberty is protected. The individual's life is protected and individual liberty is protected, right? And to protect this life and liberty, it is habeas corpus that is available. That means during national emergency, though, right, Article 32 is restricted, but not the writ of habeas corpus. The writ of habeas corpus cannot be restricted even during national emergencies. So, remember this point very carefully, because many a times a question has come on this point, right, in mains. Many a time a question has come on this point in mains, alright. So, here I will give two important case studies. One is Shivakant Shukla versus ADM Jabalpur case. One is Shivakant Shukla versus ADM Jabalpur case. One is Shivakant Shukla versus ADM Jabalpur case. Alright. And second one is Menaka Gandhi case. Menaka Gandhi versus Union of India case. So these are two important case laws that you should remember. One is Shivkant Shukla case and the second one is Menaka Gandhi case. Alright, in Shivkant Shukla case, it was held that the individual has no right to move to courts. The individual has no right to move to courts. No right to move to courts even during emergencies. That means whenever a national emergency is imposed, the individual cannot move to courts and claim remedy. That means the individual should not go to courts and ask a remedy under Article 32. That is what said by Supreme Court in Shivkant Shukla case. అంటే చూడండి, నేషనల్ ఎమర్జెన్సీ ఇంపోజ్ చేసినప్పుడు ఎవరికైనా ఎవ్వరు కూడా సుప్రీంకోర్టు నుంచి రిట్ తీసుకోవడానికి వీలు లేదు. దే కెన్ నాట్ గో టు కోర్ట్స్ అండ్ దే కెన్ నాట్ క్లెయిమ్ అ రెమెడీ, దే కెన్ నాట్ క్లెయిమ్ అ రిట్. That is what said by Supreme Court in Shivkant Shukla case. Right? If not Supreme Court, then who will protect the rights of individual? If not Supreme Court, who has the duty of protecting the rights, the life and liberty of individuals? If not Supreme Court, then whom? Now, this is the point of debate. Just now we have said that it is Supreme Court. Right? It is Supreme Court that is ultimate guardian. Supreme Court is regarded as ultimate guardian for protecting life and liberty of individuals. Supreme Court is regarded as ultimate guardian for protecting life and liberty of individuals. But here, if you take this Shivkant Shukla case judgment, Supreme Court said that the individual cannot move to courts. So don't you think that? Right? Don't you think that it is a violation of Constitution? Violation of the basic feature of Constitution? Protecting life and liberty is a basic structure. You cannot go away. Alright? So this judgment was corrected by Supreme Court in Menaka Gandhi case. Right? In Menaka Gandhi case, Supreme Court has corrected the judgment given in Shivkant Shukla case. Right? And in Menaka Gandhi case, Supreme Court said that even during emergencies, every individual has the right to move to courts. Every individual has the right to move to courts. So here, no right to move to courts, but now it is every individual has the right to move to courts. Right? So this is what the change. In earlier case, the individual was denied the right, but now the individual is given the right. Right? So even during emergencies, every individual has the right to move to courts and claim a constitutional remedy for restricting life and liberty of individuals. ఎప్పుడైతే లైఫ్ అండ్ లిబర్టీ మీద రిస్ట్రిక్షన్స్ ఉంటాయో, అది ఎమర్జెన్సీలో అయినా సరే, ఈవెన్ డ్యూరింగ్ ఎమర్జెన్సీ అయినా సరే, రైట్, ఎవరి రైట్ అయితే వయలేట్ అవుతుందో, దే కెన్ మూవ్ టు కోర్ట్స్, they can claim remedy, they can seek remedy. That is, they can seek the remedy of habeas corpus. They can seek the remedy of habeas corpus. Alright? So that means the writ of habeas corpus cannot be restricted even during emergencies. They cannot be challenged. They cannot be challenged or they cannot be restricted. They cannot be challenged or they cannot be restricted even during emergencies, right? So this is what we should remember. So remember both Shivkant Shukla case as well as Menaka Gandhi case, right? Am I clear to you? Alright, okay then. So let us just try to understand meaning of each of the writ which are mentioned in Article 32. Let us try to understand. Let us try to understand meaning of each of the word, right, which are mentioned in Article 32 of the Constitution. Right. So let us start with the word of habeas corpus. What do you mean by habeas corpus? What does this writ habeas corpus deals with? If you take the literal meaning of this word, it is the literal meaning of the word is the literal meaning of this writ is to have a body. Alright, that means the human body is always protected. Alright, the human body is always protected. That means the human body is always protected from all the forms of punishments. That means the human body is secured. The human body cannot be subjected to any kind of punishments, even amputations. ఏ రకమైన ఫిజికల్ పనిష్మెంట్ ఇవ్వడానికి వీల్లేదు. In case, then the individual can claim remedy. Right? The human body is secured, it is protected from all the kind of protections. No amputation can be done. Right? So no kind of injury can be inflicted on the individuals. Right? No injury can be inflicted, no amputation can be made. Alright? So this is the literal meaning of habeas corpus, to have a body, to secure a body from all the forms of, from all the kinds of human punishments. Alright? This is one thing. Alright? Now, if you take this, the writ of habeas corpus, the ultimate purpose, the purpose of this habeas corpus, as I said, it is to protect the life and liberty of individuals. It is to protect the life and liberty of individuals from arbitrary restrictions. From arbitrary restrictions. So from any kind of arbitrary restrictions, alright, the life and liberty is protected. So what do you mean by arbitrary restrictions? Not following the procedure given by law and what? Not following the procedure given by law, and what is the other point? Every law that is made should be just and fair, right? So one is following the doctrine of procedure established by law. One is the doctrine of procedure established by law. Second one, following the concept of due process of law. Alright, one is following the doctrine of procedure established by law, and second one is following the concept of due process of law. Right? That means every law that is made should be just and fair laws. Should be just and fair laws. Alright? So this is what you call arbitrary means. That means whenever there is an arbitrary restrictions on life and liberty of individuals, whenever there is a restriction on life and liberty of individuals, then the individuals can claim. The individuals can claim a remedy, and the remedy is habeas corpus. Alright? The purpose is to protect life and liberty. The purpose is to protect the human body from any form of what you call punishments inflicted. It can be any form, including a physical punishment, including the physical punishments. All right. So this is the writ of habeas corpus. All right. So this writ of habeas corpus is available to both citizens as well as foreigners. Right. So it is not just restricted to citizens. Right. It is available. The writ of habeas corpus is available to both citizens as well as non-citizens. That means no individual in India. It is no individual. No individual should be arbitrarily restricted of their life and liberty, whether a citizen or a foreigner, whoever it may be, no person should be restricted of their life and liberty. Right? So in case when there is such restriction, then the individuals, the affected individuals can claim every kind of remedy. Right? Citizen కావచ్చు, బయటి వాళ్ళు కావచ్చు, ఒక ఫారినర్ కావచ్చు, ఎవరైనా సరే they can claim this. Now coming to the second one, that is the writ of mandamus. The writ of mandamus. So if you take the writ of mandamus, all right, so this is a writ, right, that is given against executive. So these writs are issued against executive, public servants. It is a writ that is issued against executive or public servants. The literal meaning of this word mandamus, is we command or we order. Alright. So this is the literal meaning of the word, right, mandamus. So mandamus means we command or order. Simply, it is an order or it is a command issued by judiciary against executive or a public servant, public servant. So remember, this mandamus is issued whenever public servants fail to perform their official duties. Whenever public servants fail to perform official duty, right, and for such act, that is for such failure, if the fundamental rights are affected, right, that simply if the fundamental rights are affected because of non-performance of official duty, alright, then the affected individual, that means those individuals whose fundamental rights are violated, they can move to courts and can seek appropriate remedy. ఎవరి రైట్స్ అయితే వయలేట్ అవుతాయో, ఎవరి రైట్స్ అయితే ఎఫెక్ట్ అవుతాయో, ఆ ఎఫెక్ట్ అయిన ఇండివిజువల్ దే కెన్ గో టు సుప్రీం కోర్ట్ and can seek a remedy, and the appropriate remedy that is issued is mandamus. గుర్తుపెట్టుకోండి, this mandamus is issued against public servants, executive, because public servants అంటే ఎవరు? Public servants are a part of executive. Alright, so whenever public servants fails to perform their duty, ఎప్పుడైతే పబ్లిక్ సర్వెంట్స్ తమ అఫీషియల్ డ్యూటీని నెగ్లెక్ట్ చేస్తారో, వాళ్ళు చేయాల్సిన పని చెయ్యరో, అలా చేయకపోవడం వల్ల రైట్ ఒకవేళ సిటిజన్స్ యొక్క ఫండమెంటల్ రైట్స్ దెబ్బతిన్నప్పుడు ఎవరి రైట్స్ దెబ్బతింటాయో దే కెన్ గో టు సుప్రీం కోర్ట్ అండ్ దే కెన్ ఆస్క్ రెమెడీ, రైట్. సో దిస్ ఈజ్ వాట్ mandamus is. So mandamus is issued by judiciary against executive, alright, against executive for non performing the duty. Ultimately the purpose is to make the public servants, the purpose is to make the the purpose is to make the public servants to perform the duties and protect the rights of individuals. Let me take one simple example let me use one simple example to make you understand. చిన్న ఎగ్జాంపుల్ చెప్తా వినండి. Alright, think that municipal employees, a municipal employee has failed to perform his duty. A municipal employee has failed to perform the duty. కార్పొరేషన్ కావచ్చు, మున్సిపల్ ఎంప్లాయీస్ వాళ్ళ డ్యూటీస్ నెగ్లెక్ట్ చేసిన అనుకుందాం, బికాస్ ఆఫ్ విచ్ దెర్ ఈస్ నో డ్రింకింగ్ వాటర్. దెర్ ఈస్ నో డ్రింకింగ్ వాటర్, తాగడానికి నీళ్ళు లేవు. సో డ్రింకింగ్ వాటర్ ఈజ్ అ ఫండమెంటల్ రైట్ ఆర్ నాట్? డ్రింకింగ్ వాటర్ ఈజ్ ఫండమెంటల్ రైట్ ఆర్ నాట్? హౌ టు సీ దిస్ డ్రింకింగ్ వాటర్, వెదర్ డ్రింకింగ్ వాటర్ ఫండమెంటల్ రైటా కాదా? లేదా కొత్త స్లోగన్ వచ్చింది. కొత్త స్లోగన్ ఏంటిది? ఐ డోంట్ వాంట్ టు డిస్క్లోజ్ ఇన్ దిస్ క్లాస్, ఆన్లైన్ కాబట్టి కొన్ని జోక్స్ చెప్పలేను. సో సేవ్ వాటర్ అండ్ డ్రింక్. సో దట్ మీన్స్ think that there is no drinking water, and drinking water is a fundamental right of the individual, and here the fundamental right is affected. Here the fundamental right is affected. Yes or no? Yes, there is an effect on fundamental right of the individual. Evari valla? Because of non performance of duty by a municipal employee. So here a public servant has failed to perform his duty, because of which there is a violation of fundamental right of the individual. That means what? Now this affected individual can move to Supreme Court and claim the remedy. The affected individual can go to Supreme Court and claim remedies. Alright? So this is how, now it is in this case the Supreme Court issues an order. In this case an order is issued to the municipal employees. This is what a simple example. You see these kind of things in our society daily. It is a common thing. RTC employees going for strike, municipal employees going for a strike, right? Junior doctors going for a strike, public servants going for a strike. Of course, not all the public servants. So there are things. Normally we see these kind of strikes. వీటి వల్ల ఎవరు who are getting affected? ఎవరు ఎఫెక్ట్ అవుతున్నారు? ఇట్ ఈస్ ది కామన్ పీపుల్ అండ్ దేర్ ఫండమెంటల్ రైట్. సో నౌ ది ఎఫెక్టెడ్ ఇండివిజువల్ దే కెన్ మూవ్ టు కోర్ట్స్ అండ్ కెన్ సీక్ అప్రోప్రియేట్ రెమెడీ, అండ్ ది అప్రోప్రియేట్ రెమెడీ ఈజ్ mandamus, రైట్. సో మళ్ళీ చెప్తున్నా, mandamus ఈజ్ ఇష్యూడ్ అగేన్స్ట్ ఎగ్జిక్యూటివ్ ఆర్ పబ్లిక్ సర్వెంట్స్. ఇట్ ఈస్ ఇష్యూడ్ అగేన్స్ట్, రైట్, executive or public servants, because public servants are a part of executive. Alright, so this is the writ of mandamus. I think am I clear about it or not? Am I clear or not? Alright, alright. So now let us move towards the next writ, that is prohibition. The next writ is prohibition or prohibit. The literal meaning of the word prohibit is prohibition. The literal meaning is prohibition. Alright, it means prohibition. Alright, so simply it is very easy to remember. హూ ఈజ్ ప్రొహిబిటింగ్ హూమ్, ఎవరు ఎవరిని ప్రొహిబిట్ చేస్తున్నారు, ఇది తెలుసుకుంటే సరిపోద్ది. రైట్, హూ ఈజ్ ప్రొహిబిటింగ్ హూమ్, రైట్, అండ్ వై. రైట్, సో రిమెంబర్ ది హయ్యర్ కోర్ట్స్, it is the higher courts prohibiting the lower courts. It is higher courts prohibiting the lower courts. Simply it is an instruction given by higher courts to the lower courts, right? Instruction of prohibiting the lower courts from taking up any case, from taking up a case which is beyond its jurisdiction. తన పరిధిలో లేని కేసు తీసుకున్నప్పుడు, right, when lower courts take up an issue or take up a case which is beyond its jurisdiction, in such a condition the higher courts can simply prohibit the lower courts from giving a judgment or from going further. Right, it can stop the proceedings in the lower courts. So it is an instruction given by higher court to the lower courts whenever the lower courts act beyond their jurisdiction. Right, whenever the lower courts oversteps their jurisdiction. Right, so this is prohibition is. Alright, so it is an instruction given by higher court to the lower courts whenever the lower courts act beyond their jurisdiction. Right, and this prohibition is issued both against judicial bodies as well as quasi judicial bodies. So it is issued both against judicial and quasi judicial. That is partly judicial. So what is the best example of partly judicial bodies? What do you mean by partly judicial? What do you mean by quasi judicial? Quasi judicial or partly judicial. So what do you mean by this? What do you mean by partly judicial or can you give an example of this? Tribunals, right? So you always hear the word of tribunal. We always hear the word tribunals. So tribunals are the best examples. Tribunals are the best examples of quasi judicial bodies. Tribunals are the best examples of quasi judicial bodies. Right, so you all see this: Central Administrative Tribunal, Railway Tribunal, right, Company Appellate Tribunal, right. So we have different, so say for example what is this? National Green Tribunal, NGT. So in each and every area we have a grievance redressal system. Remember, these tribunals are a part of grievance redressal systems. They are a part of grievance redressal systems, right? So this prohibition is issued by higher courts to the lower courts, not only to the lower courts but also to the tribunals, not only to judicial bodies but also to quasi judicial bodies, right? So this is what about prohibition. Am I clear about prohibition? Alright, so next, moving on to the next writ, that is the writ of certiorari. The writ of certiorari, right? So if you take this certiorari, the literal meaning of the word certiorari is to certify. It is to certify, alright? So the literal meaning of the word certiorari is to certify. So what is certified? So what is certified? What is being certified? Alright. So to certify, it is the degree, the order, the judgments. It is the order or the judgment given by the lower courts, right? So it is a certification of the judgment. It is the certification of judgment. It is certification of an order issued by lower courts. So whenever a lower courts issues the judgments, whenever the lower courts use their opinions or judgments, the higher courts, they can accept or they can reject. That means the higher courts can certify. The higher courts have every power to certify these judgments, right? So the judgments can be accepted, it can be rejected, and the higher courts can modify the judgments, right? So that means there will be a certification. There will be a certification of what you call the judgments given by lower courts by the high courts, right? So normally we see this, right? The judgments given in district courts, they are being normally appealed in high courts, and high courts may accept or high courts may change or it may reject. The judgments given by high courts, they may be modified, they can be accepted, rejected by Supreme Court. So we have this kind of system. So we will discuss this in what we call Article 129, 130, 131. So we have provisions relating to what we call Supreme Court, right? The original jurisdiction, the appellate jurisdiction, right? We will discuss all these things, right? But as of now, remember that the higher courts have every power. The higher courts have every power to modify. అంటే కింది స్థాయి కోర్ట్స్ ఇచ్చిన జడ్జిమెంట్స్ని పై కోర్ట్స్ అది మార్చొచ్చు, రిజెక్ట్ చేసుకోవచ్చు, యాక్సెప్ట్ చేయొచ్చు. అదే సెర్షియరీ అంటే ఏంటిది? మార్చడము, యాక్సెప్ట్ చేయడం, రిజెక్ట్ చేయడం, ఇవన్నీ సర్టిఫికేషన్. ఇట్ ఈస్ సర్టిఫికేషన్ గివెన్ బై ది హయ్యర్ కోర్ట్స్ ఓవర్ ది జడ్జ్మెంట్స్ ఆఫ్ lower courts, right? So that is certiorari. Now let us now move towards the next bit, that is quo warranto. The literal meaning of this quo warranto is by what authority? It is by what authority. So what is questioned here? What is being questioned? What is being questioned? What is questioned? It is the authority behind the person. It is the authority behind the person is questioned. So it is authority of the individual. So any individual who assumes any public office, right, should possess proper authority. Any person or any individual who occupies any public office, they should possess a requisite authority. So without having a requisite authority, without having a proper authority behind them, they cannot, the individual cannot assume a public office. తెలుగులో చెప్పాలంటే ఏ అధికారము చేత, అంటే ఏ పబ్లిక్ సర్వెంట్ అయినా సరే వాళ్ళకు అధికారం ఉందా లేదా, అంటే ఆ ఫంక్షన్ చేయడానికి అధికారం, రైట్? సో అధికారం లేకుండా, రైట్, ఎవరు కూడా ఫంక్షన్ చేయడానికి వీలు లేదు. సో వాట్ ఈస్ ది అథారిటీ బిహైండ్ ది యాక్ట్, ది అథారిటీ బిహైండ్ ది ఇండివిజువల్ ఈజ్ క్వశ్చన్, రైట్? సో థింక్ దట్ ఇఫ్ ది ఇండివిజువల్ హ్యాస్ నో ప్రాపర్ అథారిటీ, then what need to be done? Think that the individual has no proper authority, then what need to be done? Should he be allowed to continue in the office? Continue cheyala a person ne? A person continue cheyala cheyakodada? When there is no proper authority behind the individual, he can be simply be quashed, he can be simply be removed from that office. So the writ of quo warranto is issued. The writ of quo warranto is issued to remove that person. That means, right, whenever there is a violation of fundamental right of individual because of a person who assumes a public office without proper authority, then the affected individual, every rights అయితే violate అవుతున్నాయో, he can move to courts, he can go to Supreme Court, and he can ask the Supreme Court to provide appropriate remedy. And the remedy that is available is quo warranto, right? So remember, this quo warranto is issued both against citizens as well as any non-citizen. So not only it is restricted to citizens, it is even for non-citizens. Both habeas corpus and quo warranto, the writ of both habeas corpus and quo warranto, they are issued against citizens as well as non-citizens. They are issued against citizens and non-citizens, right? So this is what we should know, right? So these are different types of writs. These are different types of writs which are issued under Article 32. So let me rewind all these writs once again. First one is habeas corpus. First one is habeas corpus. Second one is mandamus. Right. Third one is, the purpose here is to protect the body, to have a body. Right. An order issued or a command issued. Prohibit or certiorari, it is prohibiting. The purpose of this prohibit is prohibition, and certiorari is, the purpose of certiorari is to certify the judgment. To certify the judgments. Quo warranto, that is the authority. The literal meaning is by what authority? It is by what authority? Right? So these are different types of writs. These are different types of writs which are issued under Article 32. Right? So out of all the writs, the writ of habeas corpus is most important because the purpose of habeas corpus is to protect individuals' life and liberty from all the arbitrary acts of the state, and this writ of habeas corpus cannot be restricted even during national emergencies. That is, even during national emergencies, the writ of habeas corpus cannot be restricted, right? So, and most important case studies is, one is Shivkant Shukla case, and second one is Menaka Gandhi case. One is Shivkant Shukla case and the other one is Menaka Gandhi case. So these are two important case laws. That we should remember. Take down a question in this regard. Explain the importance of Article 32. Explain the importance of Article 32 by using Supreme Court case laws. Explain the importance of Article 32 by using Supreme Court case laws. Next question. Debate on restriction over Debate on restriction over the writ of habeas corpus. Debate on restriction over the writ of habeas corpus. All right. So this is about Article 32. All right. Now coming to Article 33 and Article 34. All right. The commonness in both Article 33 and Article 34 is it is the restrictions on fundamental rights of citizens of India. The commonness is, right, restrictions on enjoyment of fundamental rights. That means according to Article 33, certain class of citizens of India, right, they are being restricted of their fundamental rights. That is, all those citizens who are placed under armed services, the citizens of India who are in armed services and central paramilitary services. Paramilitary services, they are restricted, right? They are restricted of their fundamental right. It means though they are citizens of India, because of their duty boundness, right, their fundamental rights are restricted. That means ఎవరైతే ఆర్మ్డ్ సర్వీసెస్లో సెంట్రల్ పారామిలిటరీ సర్వీస్లో ఉన్నారో వాళ్ళు సిటిజన్స్ అయినప్పటికీ అన్ని ఫండమెంటల్ రైట్స్ వర్తించవు, రైట్? దే డోంట్ ఎంజాయ్ ఆల్ ది ఫండమెంటల్ రైట్స్. దెర్ ఈజ్ ఎ రిస్ట్రిక్షన్ ఆన్ దేర్ ఫండమెంటల్ రైట్స్, రైట్? సో and even public servants who are in during emergencies, they are denied of their fundamental rights. That is, even certain public servants who are working during emergencies, they cannot claim all the fundamental rights. So during emergencies, these public servants, they can be restricted of their fundamental rights. So this is one restriction. So restriction of fundamental rights of those public servants, right, either in armed forces or central paramilitary forces or in during emergencies, right, they are restricted of their fundamental rights. And similarly, all right, according to Article 34, the citizens of India who are under a martial law, so that is those areas where there is imposition of martial law, right, in such areas the citizens residing in that areas, they cannot claim rights, they cannot claim fundamental rights. That is, their fundamental rights are restricted. Right? The fundamental rights of those citizens who are residing in those areas which are declared as disturbed. Normally, right, this martial law is imposed in disturbed areas, any kind of disturbed areas. Recently we have seen the kind of violence took place during elections, right, where there is section 144 imposed, right? Section 144 is imposed, and here wherever there is section 144 imposed, automatically the people who are living in that area, they are not allowed, right, they don't enjoy all the fundamental rights. They don't enjoy the fundamental right. That means their fundamental rights are restricted. Their fundamental rights are restricted. So people who are in these disturbed areas, people who are living in the people living in those areas where there is a martial law is in place, right? Not only this, we have special laws. Say for example, Armed Forces Special Powers Act, AFSPA. Armed Forces Special Powers Act. Those areas where there is imposition of this Armed Forces Special Powers Act, even in these areas, the citizens living in that areas, they don't enjoy all the fundamental rights. That means their fundamental rights are restricted. సో ఏ స్టేట్స్లో అయితే ఏ ప్లేసెస్లో అయితే ఏఎఫ్ఎస్పిఏ ఇంపోజిషన్లో ఉంటుందో ఆ ప్లేసెస్లో ఇన్ దట్ ఏరియాస్ రైట్ ద సిటిజన్స్ ఆర్ డినైడ్ ఫండమెంటల్ రైట్స్. దేర్ ఫండమెంటల్ రైట్స్ ఆర్ రిస్ట్రిక్టెడ్ because of this martial law, because of this Armed Forces Special Powers Act. Alright, so this is a restriction on fundamental rights of certain citizens, the citizens who are in armed services and the citizens who are placed in disturbed areas, that is where there is martial law is in imposition. Alright, so this is about restrictions. And coming to Article 35 of Constitution, if we take this Article 35, Article 35 of Constitution empowered the Parliament to make laws, right, for the purpose of enforcement of fundamental rights. So Parliament has every power to make laws, right, to enforce fundamental rights. That means it can restrict fundamental rights, it can impose fundamental rights. But whenever we read Article 35, so though Article 35 empowered Parliament, to make laws, but every law that is made by Parliament, should be consistent. Every law made by Parliament should be consistent with the Constitution. It should be consistent. So which article of Indian Constitution deals with this? Which provision says that every law made by Parliament affecting fundamental rights should be consistent with Constitution? Can anyone in the class? Article 13. It is Article 13 of Indian Constitution. Article 13 clearly states that. So we had a lengthy debate. We had a debate on this Article 13. We have seen this during the debate on amendments to Constitution, amendments to fundamental rights. So Article 13 states that every law made by Parliament should be consistent with Constitution, right? So though Article 35 empowers Parliament to make laws, but the laws made by Parliament should be consistent with Constitution, right? So this is what Article 35 states. So these are different provisions dealing with fundamental rights. So we have completed all the provisions dealing with fundamental rights. Okay, so let us take a break of 10 minutes, and after this break I'll start DPSP, that is Part 4 of Indian Constitution. So let me talk about part 4 of Indian Constitution. That is DPSP. Directive principles of state constitution, directive principles of state policy, right? So which were adopted from Irish Constitution. They are taken from Irish Constitution. Remember, the significance of this DPSP, right? The significance of DPSP is that it is this DPSP that provides the goals for the entire Constitution. That is, the goals of entire Constitution, they are imbibed within DPSP. The ultimate goal of Constitution. The ultimate goal of Constitution, alright, you can find this in DPSP, right? So this is the most essential part of Indian Constitution. So though we give highest importance to part 3 as said by Supreme Court in Golaknath case. If you take this Golaknath case, Supreme Court held that, right, part 3, that is fundamental rights are sacrosanct principles, right? Fundamental rights are given sacrosanct position. But remember, along with fundamental rights, alright, DPSP also occupies the most important position in Indian Constitution. They occupy an important position. In Indian Constitution. Per se, alright, they provides a non-justiciable rights. So I will debate this later, but remember, even these are also the rights. These are the rights given. That means rights are given both in part 3 of the Constitution as well as part 4 of the Constitution. The difference is, in part 3 it is justiciable, in part 4 it is non-justiciable. In part 4 it is non-justiciable rights. So we have both justiciable rights as well as non-justiciable rights of the Constitution. And ultimately, the goal of this is to establish welfare state, right? Promote justice, promote equality, alright. The main purpose of part 4 of Constitution is promoting equality, justice, and thereby establishing welfare state. That is the significance. Article 38 of this Constitution, Article 38, which is in part 4, clearly held that it is the duty of the state, to promote socio-economic order. It is duty of the state to promote socio-economic order. So that is what Article 38 says. Establishing an egalitarian society, that is a society where there are no inequalities. Inequalities leni society, discrimination leni society. The ultimate purpose of this, what you call Article 38 is, the ultimate purpose of DPSP as said in Article 38 is, right, establishing a welfare state, that is a nation where there are no inequalities, a nation where there are no what you call a discrimination. That is what this Constitution is meant for. The entire purpose of this Constitution, is to establish welfare state. Right? So that is the significance of DPSP. Right? And if you take the reason for providing this non-justiciability, or the reason for not guaranteeing this is, right, in the Constituent Assembly, there was a debate went on whether to make this part 4 of Constitution, because the aim is to promote welfare state, and every provision of this part 4 is highly important. So when there was a debate on enforceability of part 4, right, B.R. Ambedkar clearly said that, right, the government should not be forced, the newly formed governments, because the government immediately after independence, the governments after immediately after enforcement of constitution, they should not be constitutionally forced to do the things. That means the newly formed government should be given adequate choice. They should be given adequate choice. They should be given adequate importance. Choice and importance. అంటే కొత్తగా ఫామ్ అయ్యే గవర్నమెంట్స్కి, కొత్తగా వచ్చిన గవర్నమెంట్స్, ఎందుకంటే 1947 మనకి ఇండిపెండెన్స్ వచ్చింది. వి గాట్ ఇండిపెండెన్స్ ఇన్ 1947. In 1950 our constitution was enforced, right? So the government should be given freedom to choose its own priorities. Government should be given adequate space so that it can choose the priorities, it can choose a different goals and work on it. Government should not be forced. Government should be given adequate freedom. So this was the logic why DPSP was not given enforceability. This is the reason why part 4 is not enforceable. The reason for not enforcing part 4 is, right, it is only to provide choice and freedom to government to choose its priorities. Right? So these are not my words, these are the words of B.R. Ambedkar on the issue of enforceability of part 4 of constitution. అంటే బికాస్ ఆఫ్ ది ఎగ్జిస్టింగ్ కండిషన్స్, అంటే అప్పుడున్న పరిస్థితుల్లో, రైట్, గవర్నమెంట్ని ఇబ్బంది పెట్టడము సరైనది కాదు అని దాన్ని అందుకే దాన్ని పార్ట్ 4ని ఎన్ఫోర్సబుల్ చేయలేదు. రైట్, ద రీజన్ ఫర్ నాట్ ఎన్ఫోర్సింగ్ దిస్ పార్ట్ 4 ఈస్ ది గవర్నమెంట్ని ఇబ్బంది పెట్టకూడదు. గవర్నమెంట్ షుడ్ నాట్ బి ఫోర్స్డ్. So as the time comes, whenever time comes, then there should be enforceability of part 4. అంటే అప్పుడున్న కండిషన్స్ తగ్గట్టు పార్ట్ 4ని ఎన్ఫోర్స్ చేద్దనుకున్నాం. అంటే ఏంటి, ఫ్యూచర్లో ఎప్పుడైనా సరే దేర్ కెన్ బి ఎన్ఫోర్సబిలిటీ ఆఫ్ పార్ట్ 4 ఆఫ్ ఇండియన్ కాన్స్టిట్యూషన్. రైట్, దేర్ కెన్ బి ఎన్ఫోర్సబిలిటీ ఆఫ్ పార్ట్ 4 ఆఫ్ కాన్స్టిట్యూషన్ ఇన్ ద ఫ్యూచర్, బట్ నాట్ ఇన్ 1950, నాట్ అట్లీస్ట్ ఫర్ 20 years. రైట్, బట్ అప్పుడు తీసుకున్న స్టాండ్ ఇప్పుడు వరకు అదే స్టాండ్ వీఆర్ ఫాలోయింగ్ ద సేమ్ కైండ్ ఆఫ్ స్టాండ్. ఇన్ 1950 ది ఫ్రేమర్స్ ఆఫ్ కాన్స్టిట్యూషన్ డజంట్ వాంట్ టు ఇంపోజ్ అ బర్డన్ ఆన్ గవర్నమెంట్ అండ్ దే గేవ్ గవర్నమెంట్ ఆల్ ద ఫ్రీడమ్. బట్ టుడే things have changed, conditions have changed, and we have achieved some of the goals of constitution. Don't you think that it is a right time for enforcing part 4 of the constitution same as part 3? అప్పుడంటే కుదరలేదు, అప్పుడున్న కండిషన్స్ తగ్గట్టు గవర్నమెంట్ ఫ్రీడమ్ అనుకున్నాము. ఇప్పుడు కండిషన్స్ మారినాయి కదా. టుడే వి సీ a change conditions, and these change conditions definitely should be taken into considerations to enforce part 4 of the constitutions. Take down a question in this point, చాలా important point. So remember, whatever I said in this class, you can get this from Our Constitution by Subhas Kashyap. ఇది మీకు the words of B.R. Ambedkar. నేను చెప్పిన ఈ B.R. Ambedkar గారి డిస్కషన్స్, it is clearly given in the book of Our Constitution by Subhas Kashyap. మీకు లక్ష్మీకాంత్లో లేదు ఇది. రైట్, బట్ హియర్ no need to purchase the book, but I only want to give the source from where I am taking this class. Alright, so take down the question at this point. Discuss the need for constitutional enforceability. Discuss the need for constitutional enforceability of directive principles of state policy. Discuss the need for constitutional enforceability of directive principles of state policy. So, you should give a conclusion whether it should be enforced or not. Alright, you should give a conclusion on this point, whether it should be enforced or not. Alright, I would like to have your answers. So, please do post your answers to our institution mail, that is Kakatiya IAS Academy gmail.com. So, you can post your emails, you can post your answers to these emails. Alright, so I have got some of the answers. Today I will evaluate it and I will return back the answers. Alright, so this is what the point. And if you take this DPSP, the general features of this DPSP are, first of all, they are a kind of instructions given by constitution. They act as guidelines, they act as instructions, they act as guidelines, they are the directives, they are the instructions, they are the guidelines, they are the directives given by constitution. To whom? These are the instructions given by constitution to the government of the day, in its welfare policies. So, when I use the word government, it can be any government, it can be government of India or any state government. So, it is the duty of the governments, to follow these provisions, in its policy making, in its welfare policies. It is the duty of the state. To follow these guidelines, may it be poverty alleviation, employment generation, removal of inequalities, or education, or health, whatever it may be. So, ultimately it is the duty of the government to provide all these kind of welfare services. Who should provide? Do you think that the private companies will provide this health and education? Do you think that the private companies have the responsibility of removing inequalities? Do Reliance and Adanis, do they take the responsibility of removing inequalities? Never. For them, what is the basic difference between government and private sector? రెండు ఒకటేనా? రెండు ఒకటి కాదు. స్టేట్ వేరు, ప్రైవేట్ సెక్టార్ వేరు, పబ్లిక్ వేరు, ప్రైవేట్ వేరు. State, that means government. Alright, private sector, government or private sector. State is always guided by the principle of welfare. Private sector is always guided by the principle of profit. Alright, so welfare and profits, whether both go together, whether welfare and profit go together, రెండు ఒకే చోట ఉంటాయా? Whether both private sector, whether profits and welfare stand together? No. Where there is welfare, there is no place for profits. You cannot expect profits and you cannot think about profit. And whenever there is an element of profit, no question of any welfare. So, wherever importance is given profits, welfare, will take a back seat. Welfare will be given a secondary position, So, private sector always works on the principle of profits, whereas the state, the public sector, the government, it always works on the principle of welfare. So, this is the basic difference between profit and welfare, private sector and state, It is purely based upon this profit and welfare, So, no private sector will provide free of cost education, free of cost health, free of cost food, because it is least bother for them, right? Providing free of cost is of least importance. It is least importance for them. All right. So that is what basic difference. That is the basic difference between these two. All right. So state is given the primary responsibility. State has the primary responsibility of providing, all right, providing all the services, all right. So that means in its welfare policies, state is required to follow the provisions mentioned in part 4 of constitution. So they act as guidelines, they act as directives for the government of the day in its welfare policies, in any kind of welfare policies, right? If you take article 37 of the constitution, article 37 of the constitution clearly states that these instructions they act as a fundamental law in the governance of the nation. They are a fundamental law they act as a fundamental law in governance of the nation. That means, right, so this DPSP should be followed in meaning of laws. They are a fundamental law in what? Fundamental law in governance. They are a fundamental law in governance of the nation. That means the state should follow these principles, these provisions in governing the people and society. All right. So this is Article 37 of Constitution. So this is Article 37 of the Constitution. Okay. All right. Now coming to the others features. So we can regard this DPSP as ethical and moral provisions. All right. They are ethical and moral provisions. So these provisions, these DPSP, they have ethical and moral character. They have ethical and moral character, right, which is essential, right? If you take constitution, it is an ethical doctrine, it is an ethical document, it is an organic law. It is an organic law, it is an ethical document. Right, because every provision of constitution in any part of the constitution, they are aimed at promoting, right, individual good as well as common good. All right, they aimed at promoting both individual good and common good. There is both individual good and common good, right? So it is promoted by this DPSP. All right. So all from articles 39 to article 51, they deal with these provisions, right? Specific provisions are mentioned from articles 39 to articles 51 of Constitution. So though DPSP starts from article 36, but still it is from 39 to 51 we have a specific provisions. And here in this class, that is in this chapter of part 4, I will discuss some of the important provisions of part 4. The most important provisions of part 4 I will be discussing in the class. So let me start with article 39 of the Constitution. Article 39 of the Constitution. So article 39 provides the most important rights for individuals. So we always talk about right to work, right to livelihood, right to education, right to equal pay for equal work. All these are mentioned in article 39. Alright. So there is a link between article 39 and article 21. Remember, article 21 is very important. So there is a link between article 19 and article 21. There is a link between Article 39 and Article 21. So whenever we read Article 39, we should also remember Article 21, because without this Article 39, there is no meaning for Article 21. Without enforcing Article 39, remember, without enforcing Article 39, there is no meaning for Article 21 of the Constitution. Right? I'll give one simple example. Article 21 talks about right to life and liberty. Article 21 talks about right to life and liberty. And we even talked about the element of right to dignity. Right to dignity. Right to a dignified life. A right to dignified life, which is a part of right to life and liberty. Right to dignified life is a part of right to life and liberty. When there can be, already we have seen this, in which case Supreme Court held that, right to dignity, right to dignified life is a part of life and liberty. In the previous class I was talking about all these things. In the previous class we had a discussion on this. Even I gave a question on this point. Different facets of Article 21, different facets of right to life and liberty. I've talked about different cases, in which case Supreme Court held that right to dignity is a part of right to life and liberty. ఏ కేసులో చెప్పింది? Anyone in the class? రివైజ్ చేయండి, రివైజ్ చేసుకోండి. I think most of the candidates are feeling pressurized for writing exams. I know that చాలామంది ఎగ్జామ్ రాయట్లేదు. కారణం ఏంటిదంటే, ఒకటి, నాట్ హ్యావింగ్ అ కంప్లీట్ రివిజన్. ఐ నో ద ప్రాక్టికల్ ప్రాబ్లమ్స్ యాజ్ యూఆర్ ఫస్ట్ టైం ఎన్కౌంటరింగ్ ద సబ్జెక్ట్స్. ఫస్ట్ టైం మీరు సిలబస్ చూస్తున్నారు, ఫస్ట్ టైం యు ఆర్ లెర్నింగ్ దీస్ థింగ్స్. ఇప్పుడే ఫస్ట్ టైం కాబట్టి I think you are not getting adequate time to revise and go for the exam. అంతే కదా. ఒకటి భయము, సెకండ్ థింగ్ మార్క్స్ తక్కువ వస్తే ఎవరేమనుకుంటారేమో అని, పర్టికులర్గా నేనేమనుకుంటానేమో అని, థర్డ్ థింగ్ ల్యాక్ ఆఫ్ టైం. రైట్, ట్రై చేయండి, ట్రై చేసి తప్పేం లేదు. వెన్ యూ కీప్ ఆన్ ప్రాక్టీసింగ్ బిట్స్ యూ విల్ కమ్ టు నో డిఫరెంట్ పాయింట్స్. బిట్స్ ప్రాక్టీస్ చేయడం వల్ల మీరు కొత్త కొత్త పాయింట్స్ నేర్చుకుంటారు. క్లాస్లో చెప్పింది, క్లాస్లో చెప్పనిది మీరు యూ విల్ ఇంక్రీజ్ యువర్ సబ్జెక్ట్. అండ్ ఇంకోటి, వెన్ యూ ప్రాక్టీస్ బిట్స్ ద పాయింట్స్ విల్ బీ ఇన్ యువర్ బ్రెయిన్. యూ విల్ రిమెంబర్ ఈచ్ అండ్ ఎవ్రీ క్వశ్చన్. దట్ ఈస్ ద రీజన్ వై యూ షుడ్ లెర్న్ ఫ్రమ్ యువర్ ప్రాక్టీస్. ప్రాక్టీస్ అంటే మార్కులు టెస్ట్ చేసుకోవడం కోసం కాదు. ఫ్రమ్ ప్రాక్టీస్ యూ షుడ్ లెర్న్ అ న్యూ థింగ్స్. It is a way where you can revise, where you can learn, where you can enrich your subject. సో ఎవరేమనుకోరు. రైట్, మీరు నిర్భయంగా 0 మార్కులు వచ్చినా ఇబ్బంది లేదు. అసలు నేను మార్క్స్కి ఇంపార్టెన్సే ఇవ్వను. ఐ నో దట్ యు ఆర్ రీడింగ్ ఫర్ ద ఫస్ట్ టైం. మీరు ఫస్ట్ టైం ప్రిపేర్ అవుతున్న విషయం తెలుసు నాకు, ఫస్ట్ టైం సబ్జెక్ట్ నేర్చుకుంటున్న విషయం తెలుసు నాకు. కాబట్టి ఫస్ట్ టైం ఉన్నప్పుడు ఇవన్నీ రావు. రైట్, సో ఈ సబ్జెక్ట్ నేర్చుకోవాలి, రివైజ్ చేసుకోవాలి, పాయింట్స్ అని గుర్తుపెట్టుకోవాలి, కంటెంట్ గుర్తుపెట్టుకోవాలి, అప్పుడు ఎగ్జామ్ రాయాలి, అప్పుడు దెన్ యూ కెన్ టెస్ట్. కానీ ఇప్పటి నుంచి అలవాటు చేసుకుంటే ఏమవుతుందంటే యూ విల్ లెర్న్ న్యూ థింగ్స్. క్వశ్చన్స్ ఎలా వస్తాయి, మనం ఎలాంటి పాయింట్స్ గుర్తుపెట్టుకోవాలి అంటే, మొత్తం చదివి ప్రాక్టీస్ చేయడం ఒకటి, చదువుతూ ప్రాక్టీస్ చేయడం ఒకటి. రైట్, వెన్ యూ ప్రాక్టీస్ అలాంగ్ డ్యూరింగ్ యువర్ ప్రిపరేషన్ యూ విల్ కమ్ టు నో హౌ క్వశ్చన్స్ విల్ బి ఆస్క్డ్. You will come to know how to remember the points, in what way the points should be remembered, in what way the points will be tested, and what kind of points you should gather for exam. ఎలాంటి పాయింట్స్ గ్యాదర్ చేసుకోవాలి, క్వశ్చన్ ఎక్కడ ట్విస్ట్ అవుతుంది. రైట్, సో ఒక పాయింట్ని ఎన్ని రకాలుగా అడగచ్చు, ఇలాంటి మీకు తెలుస్తూ ఉంటుంది. సో వెన్ యూ కమ్ టు నో ఆల్ దీస్ థింగ్స్ దెన్ యూ కెన్ రిఫైన్ యువర్ ప్రిపరేషన్, యూ కెన్ రివైజ్, యూ కెన్ హ్యావ్ అ వెరీ గుడ్ రివిజన్స్. It is, it is only then, you can have a right preparation. నెవర్ థింగ్స్ సున్నా వచ్చినా ఒకటి వచ్చినా రెండు వచ్చినా పెద్ద ఇష్యూయే కాదు. కాకపోతే ఈ క్వశ్చన్స్ అన్నీ మనకు రివిజన్స్లో బాగా పనికొస్తాయి, మన రివిజన్ని మార్చేస్తాయి. ద వే వి సీ ద పాయింట్స్, ద వే వి సీ ద సబ్జెక్ట్, వి విల్ చేంజ్ ఎవ్రీథింగ్. ఇట్ విల్ గెట్ చేంజ్డ్, రైట్? సో దిస్ ఈజ్ వాట్ యు కాల్ ద పర్పస్ ఆఫ్ ఎగ్జామ్స్, రైట్? సో జస్ట్ రివైజ్ చేయండి, చేసుకోండి, టైం స్పెండ్ చేయండి. మంచి మీకు 12:30 క్లాస్ అయిపోద్ది. ఆల్మోస్ట్ యూ హ్యావ్ ఎవ్రీ ఫ్రీ టైం. ఆఫ్టర్నూన్ మొత్తం ఫ్రీ టైమే కదా. యూ హ్యావ్ అట్లీస్ట్ 10 hours విత్ ఇన్ యువర్ హ్యాండ్. 10 hours ఉందా లేదా మీకు? మీ చేతుల్లో 10 hours ఉంది. యూ కెన్ ప్రాక్టీస్ ఇట్, యూజ్ చేసుకోండి. డోంట్ వేస్ట్ టైం, రైట్? సో రీడ్ Lakshmikant, read NCERTs, listen to class, read the the material that is given to you, right? So don't you have plenty of time and you have, right, enough resources to read. వినడానికి క్లాస్ ఉంది, యూట్యూబ్లో యూ హ్యావ్ ద క్లాస్, రైట్? యూ కెన్ రీడ్ ద మెటీరియల్, యూ కెన్ ప్రాక్టీస్. క్వశ్చన్స్ మీ దగ్గర ఉన్నాయి. మీరు ఎంత ప్రాక్టీస్ చేస్తే అంత మంచిది. సివిల్స్ ఈజ్ నాట్ ఎ టఫ్ ఎగ్జామ్. ద ఓన్లీ థింగ్ ఈజ్ యూ నీడ్ టు వర్క్ ఫర్ 1 year. కరెక్ట్గా సిన్సియర్గా 1 year వర్క్ చేస్తే ఖచ్చితంగా సివిల్స్ కొట్టచ్చు. దేర్ ఈజ్ నో డౌట్ ఇన్ దిస్. ద ఓన్లీ థింగ్ ఈజ్ ఇట్ డిపెండ్స్ అపాన్ యువర్ సిన్సియారిటీ. బాగా గుర్తుపెట్టుకోండి. సో రివైజ్, రైట్? అందుకనే ద రీజన్ ఫర్ ఆస్కింగ్ క్వశ్చన్స్ ఈజ్, వన్ ఈజ్ టు మేక్ యూ అటెంటివ్, సెకండ్ వన్ ఈజ్ టు ఇంక్రీజ్ యువర్ సీరియస్నెస్ టువర్డ్స్ ఎగ్జామ్. సీరియస్గా ఉండండి ఎగ్జామ్ అంటే, రైట్? సో వీ హ్యావ్ Olga Tellis వర్సెస్ బాంబే మున్సిపల్ కార్పొరేషన్ కేస్, Francis Corelli's case, right? It was in this case Supreme Court held that, right, dignified life, right to dignity is a part of right to life and liberty. It is a part of right to life and liberty, right? So now when there can be dignified life, when there can be dignified existence, dignified life or dignified existence, it will be possible only when there is a work, only when there is a wage based work, when you can enjoy dignity. మీరు ఎప్పుడు తలెత్తుకొని తిరుగుతారు చెప్పండి? మనకంటూ ఒక జాబ్ ఉన్నప్పుడు, ఒక రెస్పెక్టబుల్ జాబ్ ఉన్నప్పుడు, ఒక రెస్పెక్టబుల్ పొజిషన్ ఉన్నప్పుడు, ఇట్ కమ్స్ ఓన్లీ త్రూ వర్క్. రైట్ టు వర్క్ ఇది చాలా ఇంపార్టెంట్. Right to work is an essential element of right to life and liberty, because without this right to work there is no dignity for individuals, right? Without right to work, there is no dignity. Again, when we talk about right to work, right, it is wage based work. There should be wages. The amount of wage should be equal to the amount of work that is been done. Equal pay for equal work, right? There should be wages paid, alright? So right to work, right to wages, equal pay for equal work, all these are clearly mentioned in Article 39 of Constitution. They are mentioned in Article 39. Today we all talk about Narega, Mahatma Gandhi National Rural Employment Program. What is the purpose of this Mahatma Gandhi National Rural Employment Program? What is the purpose of MNREGA? What is the purpose of NREGA? The purpose is to provide at least 100 days of work. 100 days of work in plain areas or 150 days of work in hill areas. So providing a minimum work. Right to work is a guaranteed now. NREGA provides a guaranteed right to work. హక్కది ఖచ్చితంగా గవర్నమెంట్ జాబ్ ఇవ్వాల్సిందే, పని ఇవ్వాల్సిందే. And here if you take this wages paid, the wages are paid both in cash as well as in kind, right? If you take NREGA, the wages are paid both in the form of cash, as well as in kind. The wages are paid both in form of cash as well as kind. That is what? NRGA is. That means there is right to work guaranteed, there are wages given, and there are food grains given. So, right to livelihood, right to livelihood. Remember, even before NRGA, we have Swarna Jayanti Gram Swarojgar Yojana. Right? Before that, right, we have, right, remember, IRDP. This is India's first, IRDP is India's first flagship rural development program. It is first flagship program both for poverty alleviation as well as rural development, which was started as a part of 6th 5-year plan. Right? So, IRDP is India's first flagship program meant for both poverty alleviation as well as rural development. Now, why government took the responsibility? Because Article 13 states that it is the duty of the state. It is the duty of the state to provide livelihood, to provide work. We have right to education in Article 39. Right? So, education. So, it is the duty of the state to provide education. So, we have Sarva Shiksha Abhiyan. So, if you take the right to education, originally it was mentioned in Article 39, but later it was added to Article 21 by 86th Amendment Act. So, by 86th Amendment Act, right to education was added to Article 21. It is a fundamental right. It is a part of right to life and liberty. At the same time, it is the duty of the state. At the same time, right to education is also a fundamental duty. So, if you take this education, the subject of education is present in Part 3, Part 4, Part 4A, Part 9 and Part 9A. Even local bodies, Panchayat Raj institutions as well as municipalities. So, the subject of education is mentioned in all these parts. Part 3, it is in Article 29. Part 4, it is in Article 39. It is a part of fundamental duty, that is Part 4A. It is again the responsibility of Panchayat Raj institutions. Alright. So, schools, administration of schools, both in rural areas as well as in urban areas. Alright. So, that is in Panchayat Raj system as well as in municipalities. We have this. So, it is the duty of the state. It is the duty of the state to provide education. Alright. So, we have Sarva Shiksha Abhiyan, SSA. I think I have mentioned this Sarva Shiksha Abhiyan in the previous class also. Sarva Shiksha Abhiyan. Alright. Where the purpose of Sarva Shiksha Abhiyan, alright, the purpose of Sarva Shiksha Abhiyan is to provide universal elementary education. It is universal education. Alright, to all the children below the age of 14 years. It is compulsory education for the children below the 14 years. And we have midday meal scheme, which was launched in 2001. The purpose of Sarva Shiksha Abhiyan as well as the purpose of what you call midday meal scheme is only to promote education. That means Article 39 is well implemented. So, this directive is being used by government. This directive is followed by government in its policy making. Yes or no? We have seen the provisions of Article 39, at the same time how they are being implemented. How they are implemented by government. Whether they are implemented or not. Now, what do you say? On its implementation, what is your comment? That it is implemented. Definitely it is implemented. Definitely it is implemented. That is what Article 39. Coming to Article 40 of Indian Constitution, another important provision. It is this Article 40. It is Article 40 that imposes a duty. It imposes a duty on the state to organize village panchayats. Alright, if you take this Article 40, Article 40 states that it is the duty of the state. It is duty of the state to organize village panchayats. It is a duty of the state to organize village panchayats. That means the state should implement, right, this village panchayat. That is promoting grassroots level democracy. The ultimate purpose of this Article 40, the ultimate purpose of Article 40 is to promote grassroots level democracy. It is to promote grassroots level democracy. What do you mean by grassroots level democracy? What do you mean by grassroots level democracy? What do you mean by this? It is a system where people can participate at the grassroots level, at the lowest level, in the political decision making. It is people participation. It is about people participation in political decision making. It is participation of people in the political decision making, that too at the grassroots levels, at the lowest level. At the lowest level, participation of people in the, at the lowest level, right? Participation of people in political decision making process, where people can decide on the issues. The intention of Article 40, the intention of Article 40 is to promote people participation. Today we all talk about good governance. What is the element, what is the feature of good governance? When governance will be called as good governance. Governance will be called as good governance only when there is a people participation. Alright? It will be called as good governance. It will be called as good governance when there is people participation. So, people participation is an important feature. People participation is an important feature in good governance. It is the first feature. So, Article 40 of Indian Constitution, it promotes this people participation. It promotes people participation in good governance, people participation in decision making, which makes Indian system as more participative. Right? So, this is what Article 40. And if we take the implementation, we have 73rd and 74th Amendment Acts. We have 73rd and 74th Amendment Acts. So, if you look at these 73rd and 74th Amendment Acts, alright, so which are enacted in 1992, the intention of this 73rd and 74th Amendment Acts is to implement grassroots level democracy. Implementation of grassroots level democracy. So, we have both Panchayat Raj institutions as well as municipalities. So, Panchayat Raj institutions are meant to act as rural local bodies, whereas municipalities they act as urban local bodies. Municipalities act as urban local bodies. So, one is rural local body and the other one is urban local bodies. Alright. So, this is what implementation of Article 40. So, there is a directive in Part 4 of the Constitution, and this directive is implemented. This directive is implemented by government. So, that is how Part 4 has become a guiding spirit for the government of the day. అంటే ఆ పార్ట్ 4 ఏదైతే ప్రొవిజన్స్ ఉన్నాయో వాటిని గవర్నమెంట్ సిన్సియర్గా ఫాలో అవ్వడం. రైట్. సో దిస్ ఈజ్ వాట్ అబౌట్ Article 40. what I'll do is I'll start the class here for today, and before leaving the class, let us rewind what we have discussed in the today's class. Let me talk about all those points that we have discussed in the today's class. Remember, we start our discussion with Article 26. So we have covered so many articles today. We started our class with Article 26. We have completed from Articles 26 to 28. Then we have talked about Articles 29 and 30, that is educational and cultural rights. Then we had talked about Article 32, that is constitutional remedies, which are mentioned in Article 32. Then we have talked about the restrictions of fundamental rights on certain categories of people, that is under Article 33 and Article 34. Then we have talked about Article 35, which empowered the parliament. Article 35 has empowered the parliament to make laws, right, for fundamental rights. Then we have went towards part 4 of Constitution. We have discussed some of the features of part 4 of the Constitution. We had a discussion on Article 39 and as well as Article 40 of Indian Constitution. So these are the points that we have discussed in today's class. I hope you have understood the class. Any doubts for today's class? And even the one who are in online, please do ask your doubts. Please do respond, because I want the participation of each and every student, which makes me lively. When I see your comments, when I see your doubts, I feel happy and it will encourage me to take the class. My encouragement is only the kind of interaction that I have from the students, right? And this is one thing. And second thing, please do fill the Google forms, right, about optionals. All the interested candidates, remember it is only the interested candidates who want to take optional classes from us, please do enroll the Google form and send back to us, right? So we are offering public administration, political science, anthropology and sociology. So these are the 4 optionals which are offered in Kakatiya IAS Academy. So please do join our optional classes, right? And another important point that I want to convey is, please do write the answers. So if you keep on writing the answers, there will be a day after 6 months you will see a total change in your life. ఇప్పుడు మనం జర్నీ స్టార్ట్ చేసినాం, మన జర్నీ ఇప్పుడు స్టార్ట్ అయింది కదా, 6 నెలల లోపు అంటే సెప్టెంబర్ అక్టోబర్ లోపు మీ చేంజ్ కనబడుతుంది. Then you will think about the importance of all these classes, and you can compare with any other students who are taking coaching in other institutions, right? So with this note, I will stop the class here for now. We will meet in tomorrow's class at the same time of 9:30, right? And from tomorrow evening I am going to start current affairs and mains classes. From tomorrow evening you can expect mains classes from me. So both morning, in morning session I will take prelims, in the evening session I am going to take mains class.